All right, so thank you everybody for joining us tonight for this graduate meeting where we're going to talk about supported decision making. And I realized after I posted it that maybe there's some of you that don't really know what that means. And maybe I should have been a little bit more specific in what it means when we use those words. And so we are recording this. So if you guys aren't here tonight because you thought, I don't need to know about that. I already know how to make decisions in my life. Hopefully you're watching it now and you'll catch some more information about what that means, because this is a huge and very important topic. Okay, so we're really lucky tonight that we're going to be hearing from Viviana Bonilla Lopez. She is with Disability Rights Florida. And Viviana, I want you to know that everybody that I talk to, when I ask them about a presenter, everybody pointed me in your direction, and everybody had extremely wonderful things to say about you, and
that's so nice.
And just how you present and the information that you have, the wealth of knowledge that you have. So I just wanted you to know that you come very highly recommended.
Oh, wow, no pressure.
Yes. So I'm just gonna let you take it away. Thank you everybody for being here.
Thank you all, and congratulations everyone on your graduation. This is so exciting. I've heard about the program from others in the community. And so I know that you all have been on this journey learning all about policy. And so I am here to give you your first assignment, hopefully, the first bill for you all to consider supporting this session. So I'll start by kind of giving you an introduction about what supported decision-making is, and then I'll go into the work that we're doing to try to get a bill passed this session. So up here, I have the names of Michael Lincoln McCrate, who is my co-chair for the coalition that's pushing forth the supported decision-making legislation. And just want to mention him. He'll come up in the presentation because he is my partner in crime in all of this. So I'll start off with a video.
We all make tons of decisions every day. Some of them are small decisions, like whether or not you should buy that cool new video game or order pizza. Others are bigger, like deciding what kind of career you want, where you want to live, or who to vote for in an election. Everyone has the right to make decisions. Sometimes we need help with those decisions. If you're a young person or an older adult with a disability, your family, medical service provider, or someone else may ask a judge if they can become your guardian and make all of your decisions for you. This is a legal arrangement called full guardianship. Your parent or guardian might think they have to get guardianship to do things like attend IEP meetings or help you make financial decisions, but that's not true. There are other ways that people can help you make choices. For example, a healthcare proxy only helps make healthcare choices, and a Social Security representative payee only helps with some financial choices. But another option that lets you keep control of your choices is called supported decision-making. A supported decision-making agreement lays out a plan for you to meet with a person or group of people you trust. These people can be family members, friends, co-workers, or others who can help you make decisions. You pick the decisions you might need help with, who can help, and how. Your group of supporters might look through information with you and talk through the pros and cons of different choices. They might talk with you about eating healthy foods or ways to keep track of appointments. Want to choose a college, vote in elections, or change jobs? What about date, get married, or start a family? With supported decision-making, you are the decision-maker. With guardianship, the guardian is the decision-maker and makes all the final decisions. Some decisions are big, some are small, and all of them are important. Making your own choices can help you lead a happier, healthier life. If you are a person with a disability and feel like you need help making decisions, know that you have options. You have the right to decide. For more information on supported decision-making we all make tons of decisions.
So I decide with the support of people I trust. This is our slogan for the supported decision-making campaign to get this bill passed, because that's really the spirit behind supported decision-making. And supported decision-making is often presented as an alternative to guardianship and guardian advocacy. So I'll start there. What is guardianship? What is guardian advocacy? As you saw in the video, it is a legal process where if someone can't make their decisions, or in Florida for guardianship does not have capacity, then their rights are removed from them and given to someone else to exercise on their behalf. So you see that red check mark because this person doesn't have their rights anymore, and then the green check mark on their guardian. Guardianship and guardian advocacy are a little bit different in terms of how you get into this legal arrangement and who it's for, but they essentially accomplish the same thing, which is my rights are removed and delegated to someone else who makes decisions for me. So what are the rights that can be lost? The right to marry, the right to vote, the right to personally apply for government benefits, the right to have a driver license, the right to travel, to work, to contract, to sue and defend lawsuits, to decide where you live, to manage your property, to decide who your friends are and who you spend time with. So I want you to take a look at all of these. These are the decisions, how we exercise these rights that make us who we are. If you get up in the morning, have breakfast, get in your car, drive to work, go to work, come back home, spend time with your spouse, you've used up a ton of your rights. The right to get married, the right to travel, the right to work, the right to contract so that you could sign a contract at your work and to get that lease at your apartment, the right to manage property so you can buy that car, the right to decide who your friends are so you could spend time with your spouse, and the right to decide where you live. All of that just in one simple day. So think about what it would mean to not have the ability to make those choices. So we only want to do guardianship and guardian advocacy if nothing else is going to work because of what a big deal it is to take away these rights. We only want to do it when we're absolutely necessary. When we're absolutely sure that nothing else will work, when it's absolutely necessary. So what are some of the alternatives to guardianship? And actually, before we do that, I do want to make a quick distinction between guardian advocacy and guardianship. The question that we ask is different. For guardianship, we're asking, does the person have capacity? For guardian advocacy, we're asking, does the person have a developmental disability that makes it so they can't make their own decisions? The process is also a little bit different. With guardianship, we have 3 experts who evaluate the person. With guardian advocacy, the decision can be based just on the papers. So maybe IEP records, things like that. But they both end up being the same thing. The rights are removed, they're delegated to someone else. With guardian advocacy, you have to leave the person at least one right. So you can't take them all away. With guardianship, you can take away some, which is called limited, or all, which is called plenary. Okay, so this is a good place to stop with before we go into alternatives to guardianship. Does anyone have any questions thus far?
I have one.
Go ahead.
So these are all the things that can be taken away, but not all of them have to be taken away for guardian advocacy.
For both guardianship and guardian advocacy, it's supposed to be a right by right analysis. So the court for guardianship, the evaluators come in and so for guardianship, I'll kind of do them individually. For guardianship, you as a parent, maybe you're petitioning for guardianship, you might only ask for 2 of the rights, but either way, the evaluators will evaluate the person for all of their rights. It's supposed to be a right by right analysis, but in practice, it often isn't. I've seen some evaluations that will just say autism next to each right, as if that was that's not really a reason to take away someone's rights. You need to tell me a little more about why they can't exercise that right. But so technically you could end up, the evaluator could say, oh, they have capacity for 4 of their rights, but not all of them. And you would keep 4 and the rest would be removed. That's how it's supposed to happen. But in practice, it doesn't always end up that way. And with guardian advocacy, you go in asking for whatever rights you're going to remove. And it's also supposed to be a right by right analysis. There's not an evaluator there. And the burden is on the person asking for the rights to show that there isn't capacity for them. But in practice also, you know, I've heard of judges asking, well, do they have capacity for any of them? So, you know, there's a little bit of a difference between how things are supposed to work and how they work in practice. But yes, there are people who have lost only some of their rights and not all. You know. Okay, so the first alternative to guardianship, and obviously our favorite, is supported decision making. This is when, as you saw in the video, people who you trust and support people who you trust will give you support in making your own decisions. So a good example of this is whenever I have to go to the mechanic, I use supported decision making. I never understand what they are telling me. I do not know anything about cars. So I'll ask someone that I trust who does and say, is this a fair price for what's going on with my car? Does this sound right to you? And then I can make a good decision because I have the right information. So power of attorney is a legal document where I like to say you photocopy your rights. So as the person with a disability who's looking for someone to help me with a power of attorney, I would be called the principal. And I can, for example, authorize my mom as my agent to sell my property. I live in Florida, but my family's from Puerto Rico. So say I inherit something in Puerto Rico and I need help there, I might authorize my mom in a power of attorney to sell my property. That's something that is my right to do. I'm sharing it with her. We both have that right now. Healthcare surrogate designation is a document where I say that I want to give someone permission to make healthcare decisions for me and to decide whether or not I donate my organs. And this can either take effect right now, immediately, or when I'm not able to decide myself. Advanced directives are documents where I say what I want to happen to me if I am not able to say. So for example, if I have a mental health disability, I might say, if I'm ever in psychosis and I need to be at the psychiatric hospital, these are the medications that I don't want. These are the medications that have worked for me in the past. And that way they can honor my wishes. Information releases are documents where I give people access to my information. So there are two federal laws, FERPA, which protects my education records, and HIPAA, which protects my healthcare records. And I could sign a FERPA release giving my aunt access to my college records, and she could see my grades and she could talk to my professors. Representative payee is someone who receives my Social Security money for me, manages it for me, makes sure that I have my basic necessities met, and then gives me the rest to use, or they save it for me. And what I want you all to realize is that there are a lot of ways that we can help people with their affairs without having to take away their rights. So for example, if I'm someone who only receives Social Security benefits, that's all I'm getting. Do you really need to take my right to manage my property away when all I'm getting is that Social Security check? Maybe a representative payee would be enough for me to be able to manage my money. So here is a graphic of what supported decision-making might look like. And here you can see that I have the green check mark because I've kept my rights as the decision maker. And then maybe the supporter is my mom and I gave her that power of attorney I told you guys about. So I have those dotted lines and she's giving me support. I'm sharing my rights with her. She's giving me support. And then my aunt is the one who I gave that FERPA release to. So she's accessing my college records, but she can't do anything on my behalf. So she doesn't have my rights. She has that red check mark, or the red X, I should say. Sharing information and she's giving me support. The best.
Vivian, somebody asked if there is a guardianship that is done, can it be reversed later on?
We will talk about that. It's not the easiest thing to do, so it's better to avoid it on the front end if you can. But certainly, we have had as Literate Florida clients who we've helped, and we've won a couple of cases that have been in the news, and I'll tell you about them. So there's certainly a way to do it, and that's part of my practice. So I'll give you more details as we move through the presentation. So from guardianship to SDM, this is Mike's story. Mike is my co-chair in SDM for Florida. He has developmental disabilities and an intellectual disability, and he was under guardianship right after aging out of foster care. So he was in foster care, and when it was time for him to turn 18, they put him under guardianship. He was really active in the community before his guardianship. He worked with the Sheriff's Angels. He went to church. He went to the movies. He had plenty of friends. After his guardianship, became really restrictive. They moved him into a group home. He couldn't leave without permission. He couldn't travel with anyone without permission, only people on a pre-approved list. He couldn't go to church anymore. He couldn't do his extracurriculars. So guardianship is supposed to protect people, but for Mike, it ended up that his quality of life was worse. That's not always how it happens, but it can happen. And so that's something to really understand how serious it can be, right? Because those decisions were not Mike's to make anymore. And so he lost control over his life. Mike worked with Disability Rights Florida to end his guardianship using supported decision-making. And what we did was tell the judge, listen, under Florida law, if there's a less restrictive alternative to guardianship, you should consider it and you should do that. That's what the law requires of you. And so here's supported decision-making. It will work better for Mike. And the judge agreed with us. So this is how Mike uses supported decision-making. He recently got his own apartment, and his supporters include his uncle, family friends. His pastor also gives him advice sometimes. And so they worked with him to figure out what neighborhood he would feel comfortable in, what amenities he wanted, what was his budget, looking over the lease before he signed it. He loves to travel. He loves to go to Universal Studios and to Disney World. And in the past, when he's gone on trips, he's asked his supporters, okay, do I have enough money for this ticket? Can I take off time for work? How am I going to get there? Am I going to take the bus? Should I stay overnight in a hotel? Maybe I'll be too tired after spending the day with Spider-Man. And lastly, education. So Mike is currently a security guard. He is right now doing security for the New York Mets as they're doing their spring training. So that is pretty cool. And his supporters helped him look at different programs, figure out what was right for him, apply for financial aid, and afterward figure out how he would get his license. And this is a picture of him when he passed the test. So does anyone have questions now?
If you guys want to put them in the chat or say that you have a question, then we can handle it that way. The person who asked a question before about the guardianship said, I figured it was hard, just curious how it would work. As an ESE teacher in high school now, I want to know if it ever comes up so I can share accurate information with parents.
Perfect. Yeah. And so what you do specifically, I guess, if you want to go into a little more specifics, is you file something called suggestion of capacity. For guardianship and for guardian advocacy, it's called a suggestion of restoration of rights. Both times you're basically saying to the judge, I think this person, or if the person is you, I think I can exercise my rights and I don't need this guardianship. And so you present information and then they evaluate you. For guardianship, you will be evaluated again. And that expert, which is supposed to be a physician at that stage, will tell the court whether they think you have capacity or not. And then you have a chance to respond. And then the judge decides whether or not you get some or all of your rights back. With guardian advocacy, it's pretty similar, but without that evaluation, although the court does have the option of appointing an evaluator if they think that that would be helpful, but you're not necessarily entitled to it. And at each of these stages, the person with a disability always has a right to be represented by counsel, which means that they have their own attorney. So getting into the guardianship and guardian advocacy, they have their own attorney. And if they want to get out and they submit something to the court, they'll be appointed an attorney to help them with that as well. The reason why I say that it's kind of hard is that, it's expensive. You have to pay an attorney. If you are a person under guardianship who has a private guardian, or I guess any guardian, you may also have to pay for your guardian's attorney, which may or may not be opposing you in the case. And if someone is under guardianship and they're sort of isolated, it's going to be really hard for them to find an attorney or to file this on their own because it can get a little complicated. And, there could be experts that you have to hire. It depends on how each case goes. They can get a little bit complicated and expensive and time consuming. And especially for the person with a disability, if they're on their own, it can be pretty hard to navigate. So supported decision-making in the United States. We have 12 states and Washington, D.C. currently that have supported decision-making laws. They're all marked here with a star. Texas was the first in 2015, and we're hoping that Florida will be the next in 2021. There are a couple other states that are also putting forth legislation this session, so we'll see. SDM for Florida. This is our campaign. So I decide with the support of people I trust. That's our slogan. And we are at the stage where the bill has been introduced as Senate Bill 1010. and House Bill 681. In the House, our sponsor is Representative Allison Tant, and in the Senate, our sponsor is Senator Joe Gruters. So we're super excited. If you go on this website, www.idesignflorida.org, you will find everything that you would ever want to know about our bill, and also a lot of information about supported decision making. So now I will go ahead and walk you through what's actually in the bill and why you should be excited about this. This might also be a good place to stop for some questions before we move on to the bill.
If you guys have questions, put them in there. I want you guys to know, though, that Allison Tant is new in Tallahassee, and she's, correct me if I'm wrong, but she's also a parent.
She is, yeah, she is.
Of an adult, I believe he's 22, I think, who has a disability. So she has the potential to be one of our champions at the legislative level. So you guys want to keep an eye on her. She's brand new and she's already rocking and rolling with some pretty important legislation.
Yeah.
So it's pretty interesting.
And I see that Yolanda is here. I would love to give a shout out to Yolanda because she is a member of our coalition. She is one of the people who helped draft this bill. So because she is a friend and colleague of yours, you will know that it is a good bill. So shout out to Yolanda. I love it because I feel like, Yolanda, whenever I go to a presentation, you're always there. You're just so involved in the community, you and Carla. So we're very proud to have her in our coalition. She brings a lot of expertise.
There's a question. So I think it says, I think the word is just kind of switched out. I think it says, if supported decision-making is passed, how can individuals who are not your own guardian find this information?
So we are doing a lot of education work, and once the bill passes, we will continue to. Our organization does do outreach at nursing homes and places where people with disabilities who are more isolated might live. So we're hoping to continue to get the word out. What will be nice is that the bill has requirements in there for judges. So if you go in front of a judge, the judge will have to know the law and might present this as an option for you, even if you haven't heard of it before. So that's one of the things that we're hoping will come out of this. And also the law will require schools to tell students and their caregivers about supported decision-making whenever they're in that transition age and they're being told about guardianship. So there are a couple things in the bill that we hope will increase knowledge about this. But as always, whenever there's a new law, we also just have to go out and tell people about it, do more presentations like this one. So here is,
question.
Oh yeah, go ahead.
Great question. When did Texas pass it?
2015.
2015. Okay. And why is it taking other states so long to kind of jump on board?
I mean, I think they've made pretty good progress from 2015 to 2021. I mean, in just 5 years, if you don't count this year that just started, they went from 1 to 12 in DC. So that's not bad. It's actually been moving, I think, pretty quickly. And it's interesting too, because we've seen it in a lot of states that have Republican majority legislatures, which is great because that is the case here in Florida. So it seems like something that is really truly bipartisan that both sides can agree on. And that's been really nice. You know, I think Democrats, they like the idea of protecting people's civil rights. And then I think Republicans also like the idea of personal freedom, of personal liberty. And so it's a good merging of these two ideas and values that both parties have. So we've been able to capitalize that on here in Florida, and hopefully we'll keep spreading. We'll see.
Thank you.
But I agree with you. I mean, you know, a year is too long. We should all have it. We should pass a federal law. Let's do it. I don't think we actually can because it's a state-by-state issue. But anyway, so here is a picture of everybody who's in our coalition. These are all of the organizations. On top of these organizational partners, we also have individual members like Yolanda, like some of my former clients and current clients who are people with disabilities actually using supported decision-making. And we're very proud of our coalition because we really wanted to make sure that people who've actually experienced this were represented and that it was really coming from the community. And of course, that's really important to our co-chair, Michael Lincoln, because he's the first person in Florida to use supported decision-making to get out of a guardianship. So we've tried to make that a constant in our coalition.
I did have another question that came in. It
Okay.
says, how does this work legally compared to guardianship? My son will be 17 this month, and I want him to keep his ability to make decisions, but this will most likely benefit him when he turns 18. He will need some support to make some of the big decisions. Does the reversal process work the same? I see him potentially being able to eventually be able to make decisions on his own. This is all new to me as we move forward. And then somebody else says, how does this compare to guardianship?
Okay. So the difference between supported decision-making and guardianship is that in supported decision-making, you can have all of your rights and make your own decisions. In guardianship, a guardian makes all of your decisions for you. And in guardian advocacy, whichever rights you've lost, the guardian advocate makes all your decisions for you. So I always recommend for parents who are at this juncture, that's transition age, to go from least restrictive to most restrictive. So the alternatives that we talked about earlier, the least restrictive would be supported decision-making on its own. Kind of like what I do, where I seek advice when I need help making decisions. Maybe a little bit more restrictive would be I have a power of attorney, so that I'm getting advice, but I'm also authorizing people to act on my own behalf. A little more restrictive might be representative paid, because the money is coming to someone else and they're making decisions about that money. A little more restrictive than that could be maybe a trust. And then after that is probably guardianship and guardian advocacy. So you want to go from less restrictive to most restrictive, just trying things out and see how it goes. Trying things out, see how it goes. And if nothing is working, then turn to guardianship and guardian advocacy. And I think a big thing also for parents to know and to remember is that people with disabilities should not have to be perfect to keep their rights. They have the right to make decisions, to learn from their mistakes, and to just mess up and have to figure out how to fix it. And the great thing about supported decision-making is that when they make that mistake, they're going to have people with them to process, well, why did this turn out so poorly? What can I do different next time? How do I fix this? I think, we all have that friend who stays up too late and buys too much on Amazon and then tells us, and it's just sort of funny, like, oh gosh, here you go again. But imagine if our child with a disability or our adult with a disability did that, we might be like, oh, they can't manage their money. That's not fair, right? They're young, they're still gonna learn. And so it's okay to make mistakes, and it's okay to make bad choices. We have to respect that. Most of us, our parents would probably not agree with a couple of our choices that we made, but we thought were good for us. So that's always important to keep in mind, is that it's a pretty scary time, I think, for parents, but it's not all bad. Guardianship will still be there. Let those mistakes happen, take it step by step, and then move from less restrictive to most restrictive. And I'm happy to answer individualized questions about your own situation if you'd like. I'll put my contact information at the bottom. So please feel free to call me. I'm happy to sit down with you and your adult with a disability and talk about your options over Zoom. So what is actually in the supported decision-making bill? Back to the policy. So the supported decision-making bill will define alternatives to guardianship. Right now, the law says before guardianship, the judge has to consider less restrictive alternatives. But what does that mean exactly? We will create this term, alternatives to guardianship. We're going to define it. It's already in the statute, but we're going to define it. And we're going to list alternatives like powers of attorney, healthcare surrogate designation, and of course, supported decision-making. That list is non-exhaustive, which means that if we come up with something even better in 10 years, that can also be used, even if it's not in the statute. It also requires judges to explicitly consider supported decision-making before appointing a guardian or a guardian advocate. What else is in the supported decision-making bill? So we have a sample supported decision-making agreement. And those agreements are where if I want to formalize my relationship with my mom who gives me advice on my car, I may want to write it down. And then I can maybe even take that to the mechanic and say, hey, my mom's here. She's going to help me communicate with you. And here's a document that, that shows you that she can do that. Mechanics are probably less likely to ask me for something like that, but maybe my doctor will, maybe my bank will. So it says what has to be in a supported decision-making agreement, which is who's the decision maker, that's the person with the disability, who's the supporter, that's who's giving me advice, what support's going to be given. My supporters have to take an oath saying that they understand what their duties and responsibilities are, and that if they abuse, neglect, or exploit me, that they can be criminally charged. And then it also has a section of the supported decision-making agreement that tells someone who receives it, who's a little bit nervous, or I should say not a little bit nervous, who actually suspects abuse, neglect, or exploitation, that they can call DCF, and it tells them how to do it. So we've taken some steps to make sure that people with disabilities are protected when they're using supported decision-making.
That was actually a question that just came in. It was, what protections are in place for individuals that are being exploited or don't understand a bad influence when someone gets involved? We see this a lot.
Yeah, so again, this right now, if you were a bad person and you want to exploit or take advantage of a person with a disability, your go-to tool is going to be guardianship, guardian advocacy, or a power of attorney, or a healthcare surrogate designation. It's going to be a document that actually lets you act on the person's behalf without them participating. Supported decision-making agreements, and in particular under our bill, are different. Under the bill, the only things that your supporter can do for you using a supported decision-making agreement is assist you with communicating your decisions and access your information, nothing else. So they cannot actually act for you. They can't go to the bank and say, give me $100 from Viviana's account. But they could say, here's my supported decision-making agreement. I want to know how much money she has so that I can tell Viviana and we can make her budget for this month. So it's not going to be a go-to tool for exploiters because it just frankly doesn't let you do very much. Another thing that, in addition to having those protections in the bill with that oath, with that warning to third parties, it's also important to note that we've learned from states that have already passed this bill that, we have not seen an increase in abuse, neglect, or exploitation in places where we've passed this bill. And also that studies show that greater self-determination, so making your own decisions, makes people better able to identify potential abuse and protect themselves from abuse. And then also with supported decision-making agreements, often people will have more than one supporter. So it's a team of people. It's harder for just one person to take advantage of me if I have all of these community ties, if I have other people who care about me, who are working with me and can say, hey, that's a little weird.
Right. I think that that's really the important part, because we spend a lot of time in partners talking about the discovery process and how that process is not one person, but it's a team. And the team members hold each other responsible for the best outcomes for the individual who sits at the main seat. It's not everybody else, it's that person sits at the main seat. A follow-up question along these lines was, what prevents someone from assigning anyone at all to the SDM? They can be influenced to change rep payee, change APD services, things like that.
Yeah, so the person with the decision maker, if they have their rights, and I say that because under this bill, what's pretty cool about it is we saw this in Alaska and we thought that would be great for Florida because we have so many people under guardianship, is that people under guardianship can also use supported decision-making if their guardians give them permission. And it's just as a way of helping them regain capacity, start to practice making decisions using these agreements, and then be able to get their rights back. But thinking about the usual person who's going to use supported decision-making who's not under guardianship, they have all of their rights, meaning that they can make whatever decision they want. They could decide, I don't want you to be my supporter anymore. I just don't like the advice that you are giving me. And they could change, if you're the person who's assisting them at APD, they could cancel that. They can kind of switch people around as they wish. With time, they can also decide, I don't want your advice anymore in this area. I'm kind of an expert now and I just don't need it. So you do have your rights and you are able to make those changes if that's what you were asking. If I didn't quite get that right, please do another follow-up and I'm happy to try again. Okay, so what else is in the bill? It also says that supporters need to keep the information of decision makers safe. So if I have access to your private information, like how much money you have in the bank account, I can't be telling other people. I have to keep that private. And I have to make sure that I store it in a safe place, etc. So there are a couple of requirements there. It also, as I told you guys, requires schools to tell parents about supported decision-making. This is a big deal because we see that happen pretty often is schools telling parents right when their kids are turning 18, you need guardianship, you need guardianship, you need guardianship. And it's not true, but they sort of scare them. You know, you're not going to be able to go to IEP meetings, the doctors won't talk to you anymore, which is not really true. But, you know, parents get worried, that's their job. And so it could lead them to doing something more restrictive than they needed to. So here is our logo and our website up again. Please feel free to follow us on Facebook. Let me see if I have, oh, I don't have that. Okay, this is my contact information, but we are on Facebook and we are also on Twitter. And there we are at iDecideFL. And if you go to our website, you can find our Twitter and our Facebook there. But we would love it if you would join us, follow us, help us get the word out about this bill, write to your legislators. There's a toolkit for what to say to your legislators and how to call them. We have a toolkit that lets you share information about the bill with graphics and posts and images that you can share on social media. So if you guys want to get involved, we would love to have you. And then here's my contact information as well as Mike's. And we are also happy to talk to you. I'm happy to talk to you about your case if you are interested in using supported decision making. And Mike and I are happy to talk to you if you're interested in working with our coalition, supporting us in any way. So please feel free to talk to us. We would be very honored to work with you because you guys are experts now in policy. And so please come and share that with us.
Fabulous. Before I roll into more questions that might be more specific, I'm going to go ahead and stop the recording because I don't want anybody's confidential information recorded and blasted out there on Facebook. So I'm going to just wrap up this part. So thank you everybody for attending. Really appreciate you being here. Thank you, Viviana, for this great wealth of information. And we'll certainly share the information about this bill. And hopefully I can get partners to, contact their legislators. So if you're a partner and you're watching this, contact your legislators and talk to them about this bill, because I think it's super important. And yes, I mean, I see schools tell parents all the time, get guardianship, get guardianship. So thank you all for being here. We really appreciate it.